Roman numeral II. Next to personal security, the law of England regards, asserts, and preserves the personal liberty of individuals. This personal liberty consists in the power of locomotion, of changing situation, or removing one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint, unless by due course of law. Concerning which we may make the same observations as upon the preceding article, that it is a right strictly natural, that the laws of England have never abridged it without sufficient cause, and that in this kingdom it cannot ever be abridged at the mere discretion of the magistrate, without the explicit permission of the laws. Here again the language of the Great Charter is, that no free man shall be taken or imprisoned, but by the lawful judgment of his equals, or by the law of the land. And many subsequent old statutes expressly direct that no man shall be taken or imprisoned by suggestion or petition to the king or his council, unless it be by legal indictment or the process of the common law. By the petition of right, 3 Charles I, it is enacted that no free man shall be imprisoned or detained without cause shewn, to which he may make answer according to law. By 16 Charles I, chapter 10, if any person be restrained of his liberty by order or decree of any illegal court, or by command of the King's Majesty in person, or by warrant of the Council Board, or of any of the Privy Council, he shall, upon demand of his council, have a writ of habeas corpus, to bring his body before the Court of King's Bench or Common Pleas, who shall determine whether the cause of his commitment be just, and thereupon do as to justice shall appertain. And by 31st Charles II, chapter 2, commonly called the Habeas Corpus Act, the methods of obtaining this writ are so plainly pointed out and enforced that so long as this statute remains unimpeached, no subject of England can be long detained in prison except in those cases in which the law requires and justifies such detainer. And lest this act should be evaded by demanding unreasonable bail, or sureties for the prisoner's appearance, it is declared by 1 William and Mary Statute 2, chapter 2, that excessive bail ought not to be required. Of great importance to the public is the preservation of this personal liberty, for if once it were left in the power of any, the highest, magistrate, to imprison arbitrarily whomever he or his officers thought proper, as in France it is daily practised by the Crown, there would soon be an end of all other rights and immunities. Some have thought that unjust attacks even upon life or property, at the arbitrary will of the magistrate, are less dangerous to the commonwealth than such as are made upon the personal liberty of the subject. To bereave a man of life, or by violence to confiscate his estate, without accusation or trial, would be so gross and notorious an act of despotism, as must at once convey the alarm of tyranny throughout the whole kingdom. But confinement of the person by secretly hurrying him to gaol, where his sufferings are unknown or forgotten, is a less public, a less striking, and therefore a more dangerous engine of arbitrary government. And yet sometimes, when the state is in real danger, even this may be a necessary measure. But the happiness of our constitution is, that it is not left to the executive power to determine when the danger of the state is so great as to render this measure expedient. For the Parliament only, or legislative power, whenever it sees proper, can authorize the Crown, by suspending the Habeas Corpus Act for a short and limited time, to imprison suspected persons without giving any reason for so doing. As the Senate of Rome was wont to have recourse to a dictator, a magistrate of absolute authority, when they judged the Republic in any imminent danger. The decree of the Senate, which usually preceded the nomination of this magistrate, dent operam consules nequid res publica detrimenti capiat, was called the Senatus Consultum Ultimae Necessitatis. In like manner, this experiment ought only to be tried in cases of extreme emergency, and in these the nation parts with its liberty for a while, in order to preserve it for ever. The confinement of the person, in any wise, is an imprisonment, so that the keeping a man against his will in a private house, putting him in the stocks, arresting or forcibly detaining him in the street, is an imprisonment. And the law so much discourages unlawful confinement, that if a man is under duress of imprisonment, which we before explained to mean a compulsion by an illegal restraint of liberty, until he seals a bond or the like, he may allege this duress, and avoid the extorted bond. But if a man be lawfully imprisoned, and either to procure his discharge, or on any other fair account, seals a bond or a deed, this is not by duress of imprisonment, and he is not at liberty to avoid it. To make imprisonment lawful, it must either be by process from the courts of judicature, or by warrant from some legal officer, having authority to commit to prison, which warrant must be in writing, under the hand and seal of the magistrate, and express the causes of the commitment in order to be examined into, if necessary, upon a habeas corpus. If there be no cause expressed, the gaoler is not bound to detain the prisoner. For the law judges in this respect, saith Sir Edward Coke, like Festus the Roman governor, that it is unreasonable to send the prisoner, and not to signify withal the crimes alleged against him. A natural and regular consequence of this personal liberty is, that every Englishman may claim a right to abide in his own country so long as he pleases, and not to be driven from it unless by the sentence of the law. The king, indeed, by his royal prerogative, may issue out his writ ne exeat regnum, and prohibit any of his subjects from going into foreign parts without license. This may be necessary for the public service and safeguard of the commonwealth. But no power on earth, except the authority of Parliament, can send any subject of England out of the land against his will, no, not even a criminal. For exile or transportation is a punishment unknown to the common law, and wherever it is now inflicted, it is either by the choice of the criminal himself, to escape a capital punishment, or else by the express direction of some modern act of Parliament. To this purpose the Great Charter declares that no freeman shall be banished unless by the judgment of his peers, or by the law of the land. And by the Habeas Corpus Act, 31 Charles II, Chapter 2, that second Magna Carta and stable bulwark of our liberties, it is enacted that no subject of this realm, who is an inhabitant of England, Wales, or Berwick, shall be sent prisoner into Scotland, Ireland, Jersey, Guernsey, or places beyond the seas, where they cannot have the benefit and protection of the common law, but that all such imprisonments shall be illegal, that the person who shall dare to commit another contrary to this law shall be disabled from bearing any office, shall incur the penalty of a praemunire, and be incapable of receiving the king's pardon, and the party suffering shall also have his private action against the person committing, and all his aiders, advisers, and abettors, and shall recover treble costs, besides his damages, which no jury shall assess at less than £500. The law is in this respect so benignly and liberally construed for the benefit of the subject, that, though within the realm the king may command the attendance and service of all his liegemen, yet he cannot send any man out of the realm, even upon the public service. He cannot even constitute a man Lord Deputy or Lieutenant of Ireland against his will, nor make him a foreign ambassador. For this might in reality be no more than an honourable exile. Roman numeral 3. The third absolute right inherent in every Englishman is that of property, which consists in the free use, enjoyment, and disposal of all his acquisitions without any control or diminution, save only by the laws of the land. The original of private property is probably founded in nature, as will be more fully explained in the second book of the ensuing Commentaries, but certainly the modifications under which we at present find it, the method of conserving it in the present owner, and of translating it from man to man, are entirely derived from society, and are some of those civil advantages in exchange for which every individual has resigned a part of his natural liberty. The laws of England are therefore, in point of honour and justice, extremely watchful in ascertaining and protecting this right. Upon this principle the Great Charter has declared that no freeman shall be disseised or divested of his freehold, or of his liberties, or free customs, but by the judgment of his peers, or by the law of the land. And by a variety of ancient statutes it is enacted that no man's lands or goods shall be seized into the king's hands against the Great Charter and the law of the land,